Good afternoon, Sim. Good afternoon, everybody. Good afternoon, everybody, and thank you for joining this training today. We're very...
Hello, good afternoon. Can you hear me?
Afternoon. Afternoon, Mr. Kaki. How are you? Welcome, everybody, and thank you for making time for the call today and for the training. We have some very interesting an interesting session lined up for you. Just to introduce myself, my name is Steph Mushai. I am the Program Director for Governance and Anti-Corruption at the International Lawyers Project. It is a UK-based charity that provides pro bono legal support towards economic justice. This particular training is running under our anti-corruption program. I am based in Nairobi, Kenya. On the call with me is Alex, who is also with the International Lawyers Project, and she is based in Accra, Ghana. Mr. Kaki, I don't know if I can invite you just to say some brief welcoming remarks. If you're still on the call, I hope you haven't been booted off. Yes, you're still there. Okay, I think he has been booted off the call. Perhaps we'll give him a chance to share some closing remarks at the end of the training. For now, I am happy to do a round of introductions of our trainers, our volunteer expert lawyers who are joining us today. And the topic of today's training is fraud or theft of public funds and international asset recovery. For those who may not have a background or may not have joined us at last year's trainings, the International Lawyers Project, together with Madam Aisha, the Attorney General at the Ministry of Justice, partnered on some trainings last year, and including a lecture, and those included mixed topics, including things like vulnerable witnesses and some of the things that the prosecutors were facing in the community. But today we are, like I mentioned, we're looking at the first of our anti-corruption topics in a series of 4 trainings in total. So after this, there will be 3 more to go. And with us this afternoon from Accra, Ghana, is Irene Ali Derry. She's an associate at Egality Law. Egality Law is an international law firm with offices in Accra and London. Her areas of focus are corporate, commercial, employment law, and property law. And she advises on corporate governance and the establishment of non-governmental organizations. She also has experience in contracts, company policies, and due diligence when coming to acquisition of property. So she will be giving us an introduction to the topic, and then she will hand over to Ian Hargreaves. Ian is a partner at Covington and Burling, based in the UK. He has over 30 years experience in practicing law. He advises high net worth individuals, corporates, and financial institutions on major fraud in both civil and criminal elements, asset tracing, recovery, bribery, corruption, money laundering, modern slavery, and investigations, compliance work generally. He also has experience in corporate and commercial governance, I beg your pardon, risk management, commercial disputes, and cybercrime, including ransom demands and phishing claims. He has led some high-profile civil cases in the English Commercial Court, and he's also acted and or negotiated with prosecutors, such as the Serious Fraud Office, the SFO in the UK. It's a specialist prosecuting authority tackling the top level of serious or complex fraud, bribery, and corruption matters. He has also worked with the UK's National Crime Agency, investigate, amongst other things, bribery, corruption, and sanctions evasions. I could go on with Ian's bio because he has such extensive experience, but I think you have heard that you're in good hands for the purpose of today's training. And so we are going to kick off. I'm going to invite Irene just to give us an overview and an introduction, and then we will have some Q&A, have a chance for you to have a conversation and process some of the content, and then we will hand over to Ian at that stage. So Irene, most welcome.
Thank you. Thank you so much. And I am very, very excited and happy to be with all of you. I'm happy, Steph, for the introduction. I will just want to add that I have worked with the Attorney General's Department in Ghana before joining Egality Law. At the Attorney General's Department, I worked on both civil and criminal cases, and now that I'm at Egality Law, I work on a variety of cases involving fraud, anti-corruption, and asset recovery. I am very excited to be with all of you. I will just be giving a brief introduction, and then Ian will take over and delve into the actual issues to be discussed today. What I have done is I looked at the contents of the anti-corruption laws of the Kaduna states and did a very brief comparison with what we have here in Ghana, with a view of proposing one or two measures that may be adopted in the Kaduna state as well that would go a long way to help in the fight against anti-corruption. Now, it is very interesting to note that there are already a number of similarities in our laws, both in Ghana and in the Kaduna state. I took a quick glance at your audit laws, your public procurement laws, your whistleblower laws as well. And it's very interesting and exciting to know that we all have very good and sound provisions that would help in our fights against corruption. I delved more into the anti-corruption law 2018 of the Kaduna state. And then I did notice that there are indeed provisions, already existing provisions in your laws to address recovering properties that are acquired through corrupt activities. I observed that there are others on forfeiture of assets. The Attorney General actually has the power to ask for assistance from your Kaduna State Internal Revenue to furnish them with information relating to the affairs of a corrupt official. So that is very interesting to note. What I would like to just quickly add at this point is the fact that in Ghana, we have an Office of the Special Prosecutor. Now, the essence of this law in Ghana was actually established in 2018 in Ghana. And the purpose of this law was to sort of complement the efforts of the Attorney General. But in our perspective, we wanted a more independent office or an independent official who will be tackling corruption matters in Ghana. Now in Ghana, the OSP has the power to investigate. So even though we have offices such as the Economic Office and Organized Crime Office, which actually does the investigation of corruption activities in Ghana, the Office of the Special Prosecutor in Ghana has additional powers to actually conduct thorough investigations into corrupt activities. Now, not only do they do that, they also have the power to direct other government bodies to do thorough investigations and dictate how the manner in which these investigations should be carried out. That is a very important observation that in our view, we wanted to raise in this training, hoping that it's something that the Ministry of Justice in the Kaduna State may want to look at. At this point, it would be interesting to find out from the state attorneys on the call. Do you think that prosecutors in Nigeria would prefer to have such powers as well? Or do you think that it blurs the lines between investigation and corruption? Basically, I'm throwing this question to all of you just to find out what your thoughts are in having an independent office dealing with these investigations of corrupt activities. Or you think Hello, I'm getting some feedback. I don't know if someone has a question.
I say, I check this about the Wi-Fi. Check about the Bluetooth interconnection.
Hajara Jibril, please could you mute yourself, or Alex, if you could mute Hajara, please. Kindly mute. Thank you. Go ahead, Erin.
Thank you. So I was just throwing a question to the prosecutors on the call. What are your opinions? What are your thoughts? What do you think about having an independent office handling issues of corruption, investigations that are conducted into corrupt activities in Ghana? Do you think it's best to have an independent office handle that? Or you think that the prosecutors can do that on their own and they can do it very, very well? It would be good to have some feedback or thoughts on that at this point. I don't know if anybody wants to share.
You can raise your hand if you'd like to speak. If your network is a challenge, you can put your comment in the chat and I'm happy to read it out. Yes, Mariam, please unmute and go ahead. Please unmute yourself. We can see you're talking, but unfortunately we can't hear. Yes, you're unmuted now. Oh, and unfortunately we are still unable to hear you. Kindly, could you type in the chat box and I'll read it out on your behalf?
Oh, sorry. Sorry, we couldn't hear you.
Apologies. Please type and I'll read it out. Would anyone else like, while Mariam is typing?
Okay,
Would
great.
anyone, Hajara? No, you're not raising your hand. Would anyone like to respond to the question or just give their thoughts on an independent office? Either we are very shy or we don't have any thoughts. I'm hoping that someone can break the ice for everybody.
Yes.
Okay, it looks like we have no comments at this time as we wait for Mariam to type in the chat box.
Okay, I'll just continue so that when Mariam's comments comes, we can read what she has to say. But I will just briefly touch on some of the powers that the special prosecutor in Ghana possesses. So the special prosecutor in Ghana has the power to order for the forfeiture of assets. So he can order for the confiscation of property that is acquired through corrupt activities. He also has the power to direct the freezing of property. So where property has been acquired through corrupt activities and there's enough or sufficient information to tell exactly where this property is, the special prosecutor in Ghana has the power to order for the freezing of such properties. Also, he has the power to open a separate account. Now, this account is a special account where monies that are derived from the activities of the special prosecutor would be paid into. So where certain orders are made, such as forfeiture orders, where somebody confiscates property and there's enough or sufficient evidence to be able to obtain this information or enough information to trace or allocate exactly where such monies have been paid into, there can be specific orders to be made to direct that this money should be paid into the account of the special prosecutor. So this are just to mention a few, some of the powers that a special prosecutor has. It is important at this point to mention that in Ghana, it's a notional sense of independence. Like, for instance, I mean, the ideal situation is that this special prosecutor should be independent of the Attorney General. So in the performance of his functions, in the performance of the orders that has been given to him, the special prosecutor should be independent, absolutely, of the Attorney General, because we all know that these attorneys, the Attorney Generals, are appointed by the executive. And if it's the same special prosecutor who would be investigating corrupt activities of some politically exposed persons, in some cases, it may be members of the executive, then it is very important and crucial that the special prosecutor is completely independent of these people. So in Ghana, the idea behind setting up the Office of the Special Prosecutor was to give him that independence of the executive and other arms of government in the performance of his functions. But we have observed that in practice, that is not the case. The Office of the Attorney General is only permitted to prosecute under the general power of the Attorney General. So that bears the question, is he actually independent or not? But ideally, the point I'm trying to put forward here is that it's important. The Office of the Special Prosecutor is important. It has been a great tool in fighting corruption, admittedly, but the manner in which the office is set up, the measure of independence that is given to the Office of the Special Prosecutor is extremely important if we want to achieve great strides in our fight against corruption. Also, I would also want to point out at this point in time that there are other steps that have been taken in other jurisdictions in the fight against corruption. One of these important points I would like to raise is the fact that in the UK, they have actually enacted legislation called the Unexplained Wealth Order legislation. In my personal opinion, it's a fantastic tool that would help in the fight against corruption. And fortunately, we have Ian in our midst, who hopefully would delve into how a legislation like this has helped in the fight against corruption. I think basically with the little information that I know, I am not a UK qualified lawyer, but from what I have read online, the law enforcement agencies in the UK have the power in the UK to actually order for certain property that are acquired through corrupt activities to be seized and confiscated from politically exposed persons and public officials under the Unexplained Wealth Order legislation. And that is also a very interesting tool, or if that can be implemented in the Kaduna state, that would help in the fight against corruption. These are just some of our very brief thoughts and ideas after having gone through your already existing laws on anti-corruption, which we thought to share with you. At this point, I would permits me to allow for more our experts who is with us, Mr. Ian, to delve more into the issues on tackling fraud and other anti-corruption matters. Thank you very much.
Thank you, Irene. That was excellent, and hopefully all of you can hear me. Many of the points Irene made actually resonate with myself and with the position in the UK, or at least in England and Wales, in that we have the Serious Fraud Office, which is in a sense very similar to the Special Prosecutor task force or agency within Ghana, in that it It deals with both the investigation of and prosecution of fraud claims in the criminal context, not just fraud claims, but all serious criminal matters, including money laundering, including bribery and corruption, and other potential criminal offences. So that is an agency that I will refer to as we discuss the issues, I think, which hopefully will be of relevance to you as prosecutors in Kaduna State. If I just step back slightly, in fact, I've got, I don't know whether you can see it. This is an 80-page document, which is a document filed by the Attorney General of the Republic of Mozambique, and the defendants on this document include a number of parties, primarily connected with the bank Credit Suisse, concerning, in effect, a $1 billion fraud or alleged fraud against the state of or the Republic of Mozambique, connected with the development of a tuna fish industry in Mozambique and an offshore security industry based in relation to offshore boats which would protect the seas off the coast of Mozambique. And I'm actually acting in this particular case. It's a civil case, but it's a fascinating case in how the Attorney General of a particular country or state can actually bring civil proceedings against potential fraudsters or entities that have conspired to create a fraud against a state and or country, in this particular example, Mozambique. And I may touch on this particular case as we go through. I also acted I've acted on both sides of the fence, in that I've acted for the fraudsters and I've acted for the governments who have tried to recover assets from what I'd say were alleged fraudsters. I acted for an individual called Mr. Abliazov, who had allegedly stolen 4.5 billion worth of assets from Kazakhstan. And now, although the action, again, a civil action in the UK courts, although the claim was brought by a bank, in effect the central bank of Kazakhstan, it was, for all intents and purposes, a claim brought by the state of Kazakhstan against an individual trying to recover what they said were assets which had been stolen, public funds and other assets which had been stolen from the country of Kazakhstan. And that case has resulted in numerous judgments and findings, many against, unfortunately, my client, but have led to further and more relief available to foreign governments through the UK courts. And again, I hope to touch on that as we discuss the issues concerning the tackling of fraud and the recovery of assets on an international basis. But first of all, can I ask a question of those attending? Can I put this scenario to you? Because in a sense, I would be grateful to understand how you deal with issues of significant fraud and the recovery of assets. So if I put this scenario to you where public assets have been unlawfully concealed and removed from Kaduna State, you believe that they may have been dissipated or transferred or sent, or in whatever form it might be, overseas, potentially to various jurisdictions where the suspect, the alleged fraudster, who's a high net worth individual and fairly well known in the state, he has connections in those countries to which the assets seem to have gone. And let's just use the UK and or say Switzerland as countries into which assets may well have been dissipated, which are the assets of Kaduna State, which you as prosecutors want to recover. Now, in that scenario, what would you do to try to recover those assets?
Anti-corruption answer.
Was that somebody giving the answer? I've posted the question also on the chat in case anyone is having any challenges hearing.
Just share this thing and give everybody. You just go and sit down.
Ayiku, are you responding to the question? Or Hadiza?
So you could refer this any.
Alex, could you help us mute the people that are unmuted, if possible? If the host can't, can I request Mohammed, Ayiku, Hadiza, please could you mute your mics? Amanda Abisa, thank you. Okay, would somebody like to try and respond to the scenario? Public assets have been unlawfully concealed and removed from Kaduna State. You believe they may have been taken overseas, potentially to various jurisdictions where the high net worth individual who's a potential fraudster has connections, including in the UK and in Switzerland. What would you do to try and recover the assets?
Hello, Steph.
Yes, is that Sim?
Yes.
Please go ahead.
Yes. From the scenario given, I don't know if I can modify it a little. If AIM can give me that permission to modify it a little.
Yeah, by all means, yeah.
Yes, I think in Kaduna State, our anti-corruption unit have done something similar to this, where property of the government was taken out of the state, but they were able to recover it. And honestly, my colleagues are also on the platform who are in the anti-corruption unit. I'll be very happy if they can share with us how they were able to recover it, the processes they take. I think it's similar to the question that Ian just asked now, even though this is based on it taken out of the country, but we have a similar scenario within Kaduna State that was taken out of Kaduna State. So if, yes, anti-corruption units and team, please, if you can assist us with how you were able to solve that.
Hello, are you listening to me? Hello.
Yes, please go ahead.
Okay, actually, my take on this scenario painted is the fact that the anti-corruption unit of Kaduna State is actually a subnational anti-graft agency. So actually, we've not been able to sign any instrument of either bilateral or multilateral agreement with any foreign national anti-corruption agency for the repatriation or confiscation of asset that is alleged to have been stolen. So the procedure actually is that if we are alleging any particular piece of asset, be it monetary actually or landed property, is actually domiciled in a foreign country, there's a provision where we can liaise with the Office of the Attorney General of the Federation. Now, the Attorney General of Federation, because the federal government is having bilateral and multilateral agreement with foreign bodies, so we can be able to actually leverage on that opportunity to go through the procedure with the Attorney General of the Federation, and a team will be constituted to actually liaise with the foreign body to actually move with the view of actually confiscating those assets, be it in cash or landed property. It depends on the terms of the bilateral agreement between the two countries, but as a subnational body, we are not empowered to move ahead to confiscate. We have to go through the Office of the Attorney General. However, if it is within Nigeria, if I may, because I wanted to respond to Sim, if it is within Nigeria, actually, essentially, we are having power to do that. We have to go through the procedure of service of processes through the police, essentially, so that we can confiscate, whether it is in Kaduna State, Kano State, Anambra State, or other subnational states, subnational component of the federation. We can actually move in and actually, it's either we go through the civil forfeiture, which is essentially that we outline the process, we go through affidavit evidence, explain to the court. These are the reasons why we feel that this asset that is domiciled in this state, or that is actually located in this state, has been gotten from the from the resources of Kaduna State. So this is civil for future, where you actually essentially you don't go through the rigors of final judgment of the court. You explain through affidavit evidence that you have reasonable ground to believe that that particular piece of asset is the proceeds of corruption that has been perpetuated in Kaduna State. So essentially, I think I hope that makes a bit sense of the scenario of both offshore and within the national borders, how we can go about actually confiscating assets as Kaduna State Anti-Corruption Unit. Thank you very much.
That was excellent. Thank you so much for that explanation. Do you know, and I appreciate this is a national rather than sub-national position, but do you know how successful the federal the country has been in using MLA mutual legal assistance processes in other countries? Is it generally I appreciate it takes a long time and it can be quite frustrating, but do you find that is gaining intelligence and information?
Hello.
Hi.
Hello. Hello.
Hello.
The question at the end of the question, the network from this side is not has broken, so I couldn't get the last part of the question. So I don't know whether you tends to mean that actually the process of the repatriation at the national level has been a smooth sail between nations that have signed the agreement with federal government. I don't know whether you mean.
Do you find that countries are cooperating with Nigeria through the mutual legal assistance process? Are other countries helping you?
Well, I don't think. I think so far so good, but it's not up to the expectation of the anti-corruption agencies. I think some of the countries, especially when you take the example of the Abacha that has been recovered in tranches, I think that has been a progress that the federal government agency is actually appreciative of. But however, when it comes to other individuals, I think there's a form of what I would refer to as snail movement. The progress we are recording is not that significant because we have so much starch illicit funds in actually offshore companies, offshore countries. You look at the Panama Papers, Pandora Papers, the amount of expose that this publication is actually giving and compared to the amount of recovery, I don't think it's much. It's very much to say, but I think one step at a time. I think at the same time, the national bodies need to manifest and actually more commitment and more transparency in terms of how they actually manage the so-called confiscated resources. When the member state actually had succeeded in repatriating the proceeds of corruption in their country, and subsequently they realized that actually such proceeds has been squandered again. It makes them develop cold feet. But I think at the same time, the other national bodies are attaching condition to the repatriation, like what we see, whether in the Abacha loop that they made a condition that where you recall the proceeds that has been repatriated or recovered by Nigeria has been disbursed to the poor and vulnerable. I think with the advancement of such conditions, we are making a headway, but I don't think as so far we can say much has been achieved when you just suppose the recovery with the amount of diluted resources domiciled in these foreign countries. Thank you very much.
Yeah, that again, that was really helpful to understand your observations on success of recoveries from overseas, because to be honest, I think countries like the UK and other European jurisdictions have not assisted Nigeria, Ghana, other countries as adequately as they should have in the past. I think that is beginning to change to an extent. Obviously, you mentioned about there's the James Ibori case as well. And as a consequence of several of the more recent large anti-corruption cases, we're beginning to see finally the repatriation of assets to jurisdictions, including Ghana and other jurisdictions, where monies have unlawfully been corruptly taken by large international businesses as a consequence of bribes and other corrupt payments being made. So I think your observations are well received. If I may just step back then and look at how we see a natural flow of an asset recovery matter, and I'll raise issues as I go along. But the first element is the investigation, or what induces an investigation. Now, as far as that's concerned, there may well be proactive investigations by the state. It may be that sufficient funds or finances to proactively look into issues and look into potential lost assets. We in the UK suffer from a lack of funding as far as the Serious Fraud Office is concerned. And therefore, although they say all the time that they are proactively investigating matters, they're not just sitting back and waiting. They are looking for criminals. They are looking for fraudulent activity. With the amount of funds available to them, that is very, very difficult. And I think that probably will apply in Kaduna State as it does in many other countries where there just isn't the financial backing of state, the national state, to support those proactive investigations. But they do occur from time to time. The second major source of information which leads to an investigation is a whistleblower. Now, I know Kaduna State has the Whistleblower Protection Law 2018. We've been sent a copy of that. which many thanks. That is a huge, huge source of information in the West, in the UK and European countries and the US in relation to investigations. Clearly, different countries enforce or implement whistleblowing policies in different ways. In the US, for example, a whistleblower whose information leads to the recovery of assets and conviction can obtain anything up to 30% of the fine or the award that's made against the entity. So that is a huge, huge inducement for individuals to blow the whistle on fraudsters or people they believe are fraudsters. Obviously, they have to do that in good faith, otherwise they may themselves be prosecuted. In the UK, we don't have such an inducement, a percentage payable. But the key thing is anonymity, potentially, for those who are blowing the whistle. And again, that's very much in the way that you as a state manage your whistleblower laws to ensure, where appropriate, the anonymity of those who are blowing the whistle. So anything to encourage whistleblowing, both in the private sector, but also as far as the state is concerned, can only be a good thing as far as identifying potential crimes. And the other area that we have seen significantly in the last 4 or 5 years in the UK, for example, which has happened in the US for many, many years, is self-reporting. Now, I suspect, and I don't know if this for a fact, but I'm not sure how many companies, and it's sort of tied with whistleblowing, but I don't know how many companies or individuals report on themselves in Kaduna State. They confess to the fact that they may well have been subject to a corrupt act, that they are self-reporting themselves to the authorities. I suspect that is very low in Kaduna State. But on that, as far as that's concerned, what is the inducement to self-report? What encourages companies in particular to report on themselves as to their own activities? Well, the law needs to, and the prosecutor needs to be supportive of the law, a law which encourages companies to do so, for which in return they receive a cooperation benefit by cooperating in the investigation, whereby any fine or payment to the state is reduced significantly if they have cooperated with a particular investigation. We also see it in serious matters concerning competition cases, for example, where the first mover, the entity which blows the whistle on all other companies, it receives a non-prosecution agreement and therefore isn't compelled to pay anything, whereas all the other entities on which it's blown the whistle, they are criminally prosecuted and potentially have to pay a significant fine. But this concept of the carrot and stick, the carrot being a special award or benefit to the party that's making the self-report, should be supported and should be enshrined in law. Now, I'm not sure whether that is the case in Kaduna State, where self-reporting is actively encouraged by its individuals and or companies in relation to their own misdeeds. But moving on, the second element, so you commence the investigation, and you as prosecutors, if you don't have investigative powers in your own right, and that was very much the question that Irene raised at the beginning, whether you as prosecutors have both powers of investigation and the powers to prosecute. But if you're not investigating yourselves, the next element, though, would be the asset tracing. Because in a sense, if ultimately there are no assets to trace against, although judicially it is the right thing to do to try to prosecute those who are committing criminal acts, if there are no assets at the end of the day, is it worth financing the investigation and any subsequent prosecution if there are no assets to recover. And that has to be a factor that is taken into account as part of any criminal prosecution. Because if you find the assets, or if you suspect where the assets may be, that may well lead to all sorts of information, to new evidence, to the location of the fraudsters, to the location of co-conspirators. It can also give you a jurisdictional hook. For example, if you can trace assets or suspect assets exist in the UK, you can use potentially the UK courts. You can base jurisdiction in those courts or in courts of the country which are more friendly, or one might argue more sophisticated in seeking the recovery of assets. So once you go through the process of tracing where the assets may be, ensuring there are assets, and then using that possibly to gather more evidence, at that point you may well, or you should be, freezing those assets. And again, I'm sure you do this time and time again, but it's very important that if you have located assets, or in certain jurisdictions where you know where the individuals may be who are dealing with the assets, you can get asset freezing orders against them, whether that's through the criminal route with the support or assistance of the national prosecuting authority or an international prosecuting authority, or you could go through the civil route. And the document I referred to earlier, the 80-page document, the particulars of claim, is a civil action where Mozambique, the Republic of Mozambique, is seeking the recovery of money and the defaulting of guarantees it owes to various financial institutions through the English courts on the basis that there is nexus to the English jurisdiction. So you have potentially the interim relief or ability to apply for interim relief, whether that's search and seizure, disclosure of assets, freezing of assets, repatriation of assets, whatever those forms of relief may be. And that also includes, as Irene mentioned, unexplained wealth orders, which I will touch on. But they are the forms of interim relief that you can obtain, whether nationally or potentially internationally, if you have a strong or reasonable suspicion as to where the assets may be. So you've investigated, you've traced the assets, or you've traced a reasonable suspicion of where the assets are, then you've frozen or preserved those assets for the time being. The next stage is then to seek judgment, again, whether that's at state level, national level, or international level. And that clearly, together with the powers that the prosecutor uses for the purposes of preserving the assets, is very much the remit of the prosecutor in obtaining a judgment, whether that's a court judgment or a tribunal award, and whether that is a criminal court or a civil court, depending on the nature of the jurisdiction involved. Hopefully, you have been able to substantiate the claim, you've been able to build together the evidence, and you've been able to successfully prosecute the individuals or company involved. Then the final stages of the process, obviously, is the repatriation of assets, whether that's as a consequence of a court order or of a government initiative where the government has confirmed that any proceeds recovered from the entity should be returned to the country of Nigeria or potentially the state of Kaduna. But the very important point, which I think was made as part of that repatriation of assets, is transparency. Transparency of the recovery, the award that's made, and this is public transparency where everyone can see what has happened. And public transparency, actually, so long as it doesn't tip off the threat actor or the fraudster, whoever it may be, the actual process should be as transparent and public as possible to gain public confidence. And I appreciate that is a difficult commodity to obtain in certain jurisdictions. But so long as you have a transparent way in which the assets are repatriated and that those are then used for public purposes where they are clearly audited and controlled and managed, then the public will be supportive of this process because those assets will be contributing to the public good. And in a sense, this issue of repatriation of assets probably is the most important element, because if you cannot get the public on side with you, supporting you as prosecutors in this initiative, then this will be a very difficult process to gain public confidence, public support, and to encourage individuals to support you in pulling together the evidence and in supporting you in prosecuting individuals. So that is the flow that we generally apply in assisting the prosecution, in assisting claimants in actually recovering assets, whether it's on a national basis or an international basis. And I'd like to stop at that point. I've raised several issues. I'd be grateful if anyone has any comments. You may say I'm being completely naive. This is a typical English lawyer thinking about English mechanisms when you have never potentially thought to recover assets in Kaduna State, where it is far more difficult to do so. That may well be correct, but I've thrown out quite a lot of concepts, ideas, and I'd be grateful for any comments or any thoughts at this point.
I'm looking to see if there are any hands raised or anyone who would like to speak.
Hello?
Yes, please go ahead.
Okay, thank you very much for the well spoken paper. Thank you very much for that paper. Well, I would like to quickly comment on a few issues actually with regards to the anti-corruption activities and the whistleblower law and the anti-corruption law, both of which has been actually enacted in 2018. First of all, the issue of sub-report, actually in Kaduna State, we've never had such experience, and neither is the law contemplating a scenario where actually someone in Nigeria can report himself on the issue of corruption. So we've not had the experience, and the law has not made provision to that effect, based on my understanding. And secondly, with regards to some of the incentives and the actually array of protections as regards to whistleblower, especially where such is anonymous. It's glad to inform you. I'm glad to inform you on the basis of the anonymous report. I think the anti-corruption agency unit of Kaduna State has been able to file a charge against a political appointee who is in charge of a particular very, very important agency under the state. And it's on the basis of such anonymous reports that we were able to move against the person
There's a bit of feedback. I don't know if that's just me. Ian, are you able to hear?
I heard the first few comments and then the feedback, yes.
Okay, are you getting me now?
Unfortunately, the feedback is still there, Hassan.
Okay.
That's
better. Okay, now is it better now?
Yes, yes.
Yes.
Okay, I said with regards to the anonymous report. So it's on the basis of such anonymous report, we were able to conclude the investigation which has led to now we file charge and we are prosecuting a very highly political person in Kaduna State is on the basis of anonymous report. So we are utilizing the issue of the whistleblower very well. And some of the intensive incentives provided by the law, the AG, the Attorney General, is actually saddled with the opportunity or the responsibility of outlining actually a regulation that will actually provide for the percentage of incentive to be given to any such whistleblower. So when someone whistleblows in Kaduna State, it's by the provision of the regulation that when asset has been recovered, that a portion of which will be given to him. But aside from the incentives, we know sometimes Kaduna State or Nigeria generally can be volatile, is entitled to protection by the police, is entitled to be protected from any form of malicious prosecution. So we have a number of legislative instruments that actually protect a whistleblower in Kaduna State. I think this is basically the comment that I would like to make. In addition to appreciating the well-researched paper, thank you very, very much for the job well done. Thank you very much.
That is really helpful, Hassan, and it's very interesting to hear that whistleblowers can be compensated for providing information. That I think actually is quite a progressive step that you've taken in actually implementing that provision. If I may just touch on some of the problems or some of the issues that arise from both a domestic and international basis in these types of matters. First and foremost, I think you've got to determine whether all your agencies are actually pulling in the same direction and working together. And that's not is easy to determine. For example, are you confident that if you need help from a different, say, Department of Agriculture or the Department of Business, or in pulling together information which will assist the prosecutor, are you confident that there isn't someone in another agency who has a vested interest who might be working against you? So that happens all the time and is a really difficult issue for domestically to actually create a scenario where you have a common intention to go after a particular fraudster. And I appreciate that is a difficulty that prosecutors face. Other things we see are that, as I mentioned before, that prosecutors and the investigation teams are not properly financed. You just don't have the funds to investigate. They're not always properly staffed, and again, that needs to be addressed if it's not, if it hasn't been looked at. Are there the people within the agency that have the requisite knowledge and experience in these particular matters? I'm absolutely, convinced that there are within Kaduna State, but are you being properly trained? Are there people with the necessary numeracy to understand monies are hidden within banks and the like? Do you have that internal experience and capacity? One thing that we're seeing a lot these days, and I appreciate it may or may not be relevant to Kaduna State, but is the use of crypto assets. Do you feel that you fully understand how crypto assets are being used and how you can investigate the use of crypto assets and the prosecution of those entities who are using that as a way in which to launder proceeds of crime? That is a really difficult question, although actually the blockchain technology and artificial intelligence can greatly assist on breaking down the anonymity of the use of cryptocurrencies. We're seeing greater regulation of crypto agencies. So now it's, if you need to find out where assets may have gone, you can turn to the crypto exchanges and the wallet holder providers, and they can help or information as to the individuals concerned. You need clear, concise policies and procedures. Again, from looking at the legislation that's been introduced in Kaduna State, it looks as if you have the legislation there. But those transparent procedures and policies need to be consistently applied, again, to win the confidence of the public. You need to use whatever resources you have, whether that's through surveillance, through covert investigations, to try to unearth further evidence and information. There needs to be proper record keeping. And again, I'm not familiar with how you collate the data and the evidence that you have. We have struggled dreadfully in the UK to build a national computer of information in relation to criminal offences. We now have that. But for many, many decades, frauds, thefts, corruption was not being identified because there wasn't a central repository where the information was contained, which prosecutors could turn to and use in actually building a case against individuals. And that resource, that collection of data and the accessibility of that data is absolutely crucial in assisting the prosecution in proving its case. You need a clear plan of action, a clear case strategy from the outset. Again, I'm convinced that there is the competence and the ability within the state to actually work together to create that type of internal, clear, concise strategy which is going to work. So these are all issues that I'm sure you have already at the top of your minds and you're implementing. But sometimes it's worthwhile just stepping back and just looking at the agency, looking at the team of prosecutors you have, looking at the processes and procedures you apply, looking at the legislation and think, do we have a clear strategy? Do we have a clear plan that we can roll out time after time after time when we're looking to prosecute offences of this nature? Do we have one investigation? Do we ensure that there is one investigation investigating these particular issues, one prosecutor, rather than disparate groups of people going off in different directions, looking at issues and trying to pull together evidence? It's really, really important that you have that central coordination that has public support and has support within your team. So, if I may, if I can just turn to a slightly wider international consideration. Using that scenario I gave before about assets which may well have gone to the UK or to Switzerland, wherever it might be, or even on a national level within the Federal Republic, you should consider what, as prosecutors, you can obtain by way of intelligence and information, what type of orders you can obtain. Now, if you have a suspicion that information documentation is held in the UK. There are 2 or 3 different ways you can obtain that information. You can talk agency to agency to seek voluntary assistance, and that will depend from jurisdiction to jurisdiction whether the National Crime Agency, for example, in the UK, will support or volunteer time and money and effort in helping you by giving you information it may hold on Nigerian nationals who are living or working or transferring funds into the UK. So there's the voluntary process, and it's definitely worth asking, because if you don't ask, you don't get. But there is that, and I do see it on many occasions. We had a case recently where we literally went to the Dutch police, and I appreciate there's a fairly strong relationship between the UK and Holland. But we went to the Dutch police, and they immediately handed over all sorts of data that we asked for, and they did it on a voluntary basis. Secondary, if you've got the time and the inclination to do so, there's mutual legal assistance. Third route, and the route which is often overlooked, is the use of civil courts, especially in common law jurisdictions for which you will be familiar, including the UK. You can obtain a huge amount of information very quickly through the civil courts and not even going through a criminal route. You can obtain through the civil courts disclosure orders against individuals on an interim basis. You can seek a freezing injunction against an individual dealing with assets to a certain limit. You can seek orders compelling them to deliver up assets to the court or to a law firm, so that preserves that particular asset for the time being. You can get an order against a particular property to seize or at least protect that asset whilst you build your case against the individuals. You can get a search and seizure order where through the civil courts, where you can search premises under a civil order, where you can seize assets from a building or wherever it might be under a civil order. And remember, by taking a civil course of action, the test applied is on a balance of probabilities. It is not tested on the beyond reasonable doubt test that we have in the UK in relation to criminal actions, and which I think is fairly common across most jurisdictions. So the test is lesser. It's a balance of probabilities. So therefore, you only have to show, in effect, there's a reasonable suspicion and that you have a substantive claim against the particular entity or individual. As far as criminal relief is concerned, this has also expanded exponentially within the UK over the last 10, 15 years, and in many jurisdictions, including the US, including the European states, whereby you can get a lot more through the criminal route than you ever could. And they've often mirrored the forms of relief that you can get through the civil courts in the UK. For the forms, again, you can get an order seizing cash as it enters the country. You can get an order seizing the proceeds of bank accounts or building society accounts if you can identify them. You can get orders seizing precious goods, for example, gold, jewelry, assets of that nature on their entry into the UK. You can get unexplained wealth orders, which Irene mentioned, which is simply a policeman acting on your behalf, whether on a voluntary basis or through a mutual legal assistance, where the policeman turns up at the magistrate's court, shows evidence that it is highly suspicious that individual A can own a £3 million mansion in North London on the basis that individual A, as far as we are concerned, whilst he or she was in the UK, stacked shelves in a local DIY shop, which was very much the Egality case. Now, the criminal authorities would have far more powers against an Egality character, because they'd be able to go to the magistrate and say, it is highly unlikely that this individual could afford a property of that nature. And so long as the magistrate is with you, the magistrate will order that the individual provides disclosure of his or her assets and how that individual was able to buy a £3 million mansion in North London. This applies to all property that you can identify over the value of £50,000, and that's actually coming down. So actually the figure is very low, and that will give you the disclosure of information, which may well lead then to more enquiries and more information as to the assets of the particular individual concerned. And on the basis of that, you can also seize an order, or rather you can obtain an order seizing the property or preserving it for the time being until judgment is obtained in relation to that particular individual. So that protects the asset, means he can't or she can't dissipate it, can't basically sell it on to another party. So there are lots and lots of forms of relief that many countries now provide, both through the civil courts, where there's a test of balance of probabilities, or through the criminal test, or through the criminal forms of relief, again, many of which now also apply the balance of probabilities test. And as a consequence of the Proceeds of Crime Act in the UK and similar pieces of legislation across many jurisdictions now, the concept of money laundering has given the prosecutor far more ammunition now to go after an individual or entity. Because, especially in the UK, for example, rather than having to prove that there has been an underlying crime, all the prosecutor needs to establish to get the forms of relief under the Proceeds of Crime Act for money laundering is that there is a suspicion that an underlying crime, whether that's corruption, whether that's fraud, whether that's other forms of theft, there's a suspicion that the individual has committed an underlying crime and that proceeds have resulted from that crime. And then you are entitled to enforce against those proceeds on the basis that if that person was to deal with those proceeds, there would be money laundering. So often the prosecutor in the UK in particular, and in the US now, and across Europe, are using legislation which relates to money laundering to obtain interim relief and to obtain substantive judgments against individuals and companies on the basis that it is easier to prosecute and convict someone under money laundering offences than it is potentially under the substantive offences which underlie the laundering of proceeds of crime. That is, in a sense, a very brief overview of the forms of interim relief that can be obtained overseas. And again, there has to be a certain amount of trust and reliance on cooperation from overseas courts, overseas investigative authorities and agencies and governments. But I do get the feeling, and this is something that's been pronounced quite significantly by the current director of the Serious Fraud Office, is that they are adamant that they will do more, work more, cooperate more with foreign governments and foreign law enforcement agencies. That is one of the clear missions of the Director of the Serious Fraud Office, to work with foreign governments, both for the benefit of the United Kingdom, but for the benefit of foreign states, to work with and obtain repatriation of assets. So I would strongly recommend that you can always consider that, whether, and I appreciate at a subnational level, you don't necessarily have that power, but to work with national levels to obtain that mutual legal assistance and or voluntary assistance from a foreign law enforcement agency. Now, I just want to touch on two other points. To assist in this, what can be quite a complicated process, you need to build relationships. You need to build relationships, I would say, at state level with, if possible, with overseas law enforcement agencies and prosecutors, by reaching out and connecting with them. I appreciate there may be some sensitivity with the national position, and I leave that to you to decide. But you need to build up a book of addresses or of contacts in other jurisdictions which will help you, and that's law firms, that's accountants, that's forensic accountants, that's investigators, that's tracing agents. You need to have those contacts at hand, because if you, as prosecutors, want to seek these forms of relief, you will need to have substantive evidence. You will need to be able to work with experts in other jurisdictions who can help you build the case, both domestically and internationally. Now, the second point that leads from that is, well, that's all good and that's great. But, you know, you're in a US law firm, UK law firm that charges £1,000 an hour. How can we as a state afford that? Well, look, I absolutely agree with that. Asset recovery, asset tracing is incredibly expensive. And you're facing a very sophisticated opponent, potentially, a sophisticated fraudster, a sophisticated corporate structure, may well be an offshore structure which is really difficult to penetrate. But there are law firms, there are forensic accountants, there are mechanisms, there are structures that can be put in place whereby there's a share of recoveries. And again, that would need to be incredibly public and transparent, because you wouldn't want to be accused of sharing huge amounts with a foreign entity, a foreign law firm, or whatever else, unless that had in effect received public sanction. But you can work with foreign law firms, foreign accountants, forensic accountants, whereby, you know, you can reach a conditional fee agreement or a contingency arrangement where where a percentage of the damages recovered or the proceeds are payable to the agencies that have assisted you. There are pro bono organisations that can assist. We work very closely with the Clooney Foundation, Amal Clooney and George Clooney, who have a huge fund which assists in assisting individuals or entities that are subject to unfair trials, for example. There are agencies out there that may well assist, at least at the outset, in pointing you in the right direction with some financial support. There are agencies such as the United Nations, such as the World Bank, which will assist where necessary, especially if it has an interest in recoveries received. So there are agencies out there, there are costing structures that can be put in place, but at the end of the day, this is really expensive in place. But so long as you have the contacts, you know, there are people like myself that would definitely, you know, you could bat things off me, you could ask me questions on a free of charge basis, but there are organizations that will do this. And there are ways in which we could structure an investigation and a successful prosecution at the end of the day, because this expertise, this technical expertise, especially in overseas jurisdictions, is absolutely paramount in getting you to the assets quickly, in getting those assets frozen and protected and preserved, and ultimately in obtaining the recovery of them through court judgments, whether that's criminal or civil. Again, I'll stop there. I've thrown out a lot of issues, most of which I'm sure you're already familiar with, but if there's any questions at this stage, I'd be grateful if you'd raise them now.
Hello?
Steph, are you seeing anything?
Yes, I'm trying to ask a question.
Go
Hello?
ahead, Hassan.
Yes, in the course of your explanation, you started saying that there are three procedures, three ways in which actually as a subnational agency, anti-corruption agency, we can be able to have information with regards to starch resources or asset in foreign lands. So you started with an agency to an agency, where an agency can speak with a counterpart agency in the foreign country. But the other two procedures, actually, I don't know whether I missed them actually, or you skipped them. I don't know.
Yes, sorry. There's the voluntary cooperation where there is simply a contact. You contact a law enforcement agency and they volunteer the information without having to go through what is the second process, which is mutual legal assistance, whereby you have to go through diplomatic channels, which can be time consuming, costly, but is the second route. So the voluntary cooperation, mutual legal assistance through diplomatic channels, and the third way is through the use of the civil courts, where you as a state would have you'd have standing to bring a claim, as the Republic of Mozambique has done through the English courts against Credit Suisse and various individuals. You would have the legal standing to bring a civil case against suspected fraudsters, through which you could obtain disclosure of information, you could freeze assets. So there are three routes potentially: voluntary cooperation, mutual legal assistance, which generally are in the criminal sphere, and the third route is through civil proceedings in the jurisdiction in which you suspect there are assets to recover.
Thank you very much. It's very clear now. Thank you very much. Thank you.
Any other questions or comments, clarifications? I'm trying to scroll through the list of participants. I can't see a hand up. You're also welcome to use the chat.
Hello.
Yes, Hassan, you have, go ahead.
All right, thank you very much. There's just a little comment on some of the challenges you actually highlighted, especially when it's regards to corporations from other ministries, department, and agency. I think from our experience, I'm an investigator actually from the anti-corruption unit. So from the experience we have in some of the cases we're investigating, we have a case, particular case of double payment that was met in regards to a certain company was paid for a contract it has never bid it nor executed, So actually we are trying to lay our hands on all relevant documents, but the said ministry concern is not cooperating, or rather I would say the staff in the ministry are not cooperating. So the issue of cooperation from MDAs, ministries, department of agencies is a huge challenge also in the anti-corruption unit of the Ministry of Justice here. Now, with regards to unexplained wealth order, and we may not really have it in our legislation like in bold letters, but from judicial pronouncement, especially of the Superior Court, we have what we call civil forfeiture. And I think I keen it to the issue of unexplained wealth order in the UK, which is essentially where actually someone is living above his known means of livelihood. Actually, you can be able to file, as I said earlier, an affidavit with evidence. And fortunately, again, for us, we have even land registry, Kaduna State Geographic Information Service, where all landed properties are actually collected in a database, so you can easily be able to trace. And whereas a government official cannot be able to, ideally by his non-source of income, he cannot be able to afford such asset, you can move by way of what we call civil forfeiture and actually confiscate such asset. So I think though it may not be codified in a formal legislation, it has found blessing with the Superior Court judgment, and that's very, very important. I think that's the little comment I would like to share. Thank you very much.
Yeah, that is really, again, very, very helpful. And I think, yeah, we have civil forfeiture in the UK and as well. And I think that the benefit of unexplained wealth orders is that to get civil forfeiture in the UK, you have to build the case, you have to pull all the evidence together, you have to present that case for seeking forfeiture potentially with an opponent and before a judge who will not necessarily just give civil forfeiture easily. Whereas with unexplained wealth orders, really, to be honest, a constable, a policeman can simply pitch up at a magistrate's court through the criminal route and simply argue a case on an ex parte basis, saying, you know, Mr. A, he stacked shelves at B&Q DIY shop. He's living in a £3 million property. Make an unexplained wealth order, and actually, it's a really quick, short process, and is then there's a return date in which the individual against who the order is made then has the opportunity to explain why they've been able to buy a £3 million property. But it's often a very cost-effective, quick criminal way of criminal route of obtaining quite a stringent power early on. Just one further comment, you talk about the land registry. I think it is important just to, as part of the investigation process, as part of the prosecution building the case, in that a lot of jurisdictions now are introducing legislation which is really aimed at two things: identifying beneficial ownership. Now, this might not be as much of an issue in Kaduna State, but in many jurisdictions, actually understanding who owns that particular property or asset is really difficult because it's mired in all sorts of trusts and complicated offshore structures. Now, the intention of this legislation is effectively to do away with all that, to force the property owner, where it's an overseas property owner, and looking very much at Russian oligarchs and kleptocrats, identifying exactly whether that's Putin, whether it's Abramovich, whether it's some other dictator or beneficiary of a dictator, identifying exactly who the beneficial owner of that property is. And legislation was introduced in the UK back in 2022 and is being introduced this year. Now, some might argue it hasn't worked, and it hasn't fully worked, but countries across Europe are introducing these beneficial ownership registers in an attempt to flush out the complexity of structures. And you can use this, you can access that information potentially to assist you in building a prosecution in your state or potentially at national level. The second element of that is there has been over the last 10, 15, 20 years, scrutiny of professionals, whether that's law firms, accountants, real estate agents, I'm sure you're familiar with the concept of KYC, know your customer, or customer due diligence. That is finally beginning to bear fruit, in that because there are very strict regulations on only doing business with people who you know and you can identify, that is meaning that it's becoming much easier to identify potential fraudsters or whatever else in actually carrying out the KYC processes that the banks, the lawyers, the accountants have to carry out according to regulation. And one other thing, which is a corollary of that particular point, is that many governments now, and I'm sure this may well come to play in Nigeria as well, but many governments are introducing legislation which are looking at what I call the enablers, making it far more easy to prosecute the solicitors, the accountants, the tax advisors, the auditors who are facilitating others, that's the criminals, in dealing with proceeds of crime and actually committing criminal offences, whether that's tax evasion, whether that's bribery and corruption, whatever it might be. So the UK government is going after the solicitors, one might call them, using colloquial terms, the bent solicitors, the bent auditors, the bent accountants, who are enabling criminals to own assets and to deal with assets which are proceeds of crime. And there is a plethora of new legislation across Europe which is attempting to flush out beneficial owners and to flush out the enablers, those professionals who are enabling criminals to move their assets. And again, this is providing a whole Pandora's box is opened of data and information now. So again, you might need you might need to talk to me, you might need to talk to someone else as to how you can obtain that information. But that is becoming more readily accessible, and I'm sure will be enforced, implemented at some point, if it already hasn't, within Nigeria going forward. And really, I think, Steph, I don't really have much more to say today. What I'm going to do is I'm going to send you some of the comments, the materials that I've referred to now, and I intend to pick that back up during the further sessions that we have over the next month or so, if that's okay.
That's fine. Thanks very much, Ian, for that comprehensive dive into fraud and international asset recovery. Thank you for the participation, the questions, and the attendance this far. I think we are 15 minutes early. We can start to wind up for now, just to let everyone on the call know. You've probably received this information already, but just as a reminder, we have 3 more trainings. The next one will be on liability for corruption offenses, whether individual, corporate, or other. And then we're going to talk about complicity of lawyers. And lastly, we're going to talk about national or devolved approaches to addressing corruption and corruption risks. So the next training is going to be on Tuesday, the 21st of February. And then the last two trainings will be in March on the 7th and 21st respectively. So please do join us again. Invite your colleagues that were maybe not able to join today. Sorry, Irene, I can see your hand is up.
Yes. Just a few additions to Ian's.
Sure, please.
Yes, I must add that it was a very brilliant and fantastic presentation. I have learned a lot from it. I just want to add just two points. One on I believe that access to information is extremely important in a fight against corruption. And basically, most of the steps that you'd be taking, or the steps that have been outlined by Ian, to a large extent depends on the information that you have right from the onset, because you can't even start investigations if you don't even know what you're investigating on. I don't know how the kind of legislation in place in the Kaduna state that allows attorneys or even ordinary citizens to have access to relevant information to even kickstart the process in the first place. What I would just recommend or suggest, in addition to the extremely beneficial points Ian has raised, is putting in place a very solid legislation in place that allows for access to all this sort of information. I would want to just suggest or mention that there's a Right to Information Act, which is in Ghana. I don't know what it is called in Kaduna, if it exists, but I can suggest that it's something that has helped, because ordinary citizens can just walk into any agency, public agency, politically exposed person, and request for a number of information. And once the required procedure under the Act is followed, the information will be readily available to that citizen. And my second point would be on beneficial ownership, like Ian raised. It's extremely important, because you need to know who are the names behind what is actually happening. And in Ghana here, before you can even register a company, you have to disclose who the beneficial owners are. So it's not enough for you to set up a company and say it is A and B company, which would aid in or mention the objects of the company without stating who are the names behind the company, who are those who will be directing the affairs of the company. Those names have to be disclosed. Whether or not they are even directors or members of the company, those names have to be disclosed. So yeah, these are just my few additions to the conversation. Thank you.
Thank you very much. Just to pick up on that last note of beneficial ownership, I think the federal government of Nigeria has progressed quite a bit in this area. I believe they have a register, but it may be in the extractive sector, but my colleagues can correct me if I'm wrong, but they have, there's good progress there. So thank you for the encouragement and the impact that can have on anti-corruption and on illicit financial flows as well. Any last interventions, thoughts, remarks from the participants before we close out for the day? Okay, none there. So mine is to thank the participants for joining us today, to thank our trainers, our volunteer trainers today, Irene and Ian, for the great content and background and information that they have been able to share with us. It's really been a great kickoff start to the series of trainings. Really looking forward to what's in store for the other three. I hope our participants are able to work on the documentation that will be sent, just to be able to process the information. If based on the other topics coming up, you have any questions in advance that you would like them to consider answering, you're welcome to send those through, either through Sim or Hadiza. and we can share them with the trainers to be able to answer on the topics coming up for discussion. So feel free to ask the questions and they'll be happy to prepare. But for now, allow me to wish us all a good rest of the day with thanks to everybody and hope to see you at the next training.
Thank you.
Good evening, good afternoon. Bye.
Thank
Bye.
you. Goodbye.
Thanks. Bari mu fita tukuna sai mu yi zancen.